Good afternoon, everyone. I think we can now start, and people can join as we start the session. We are 10 minutes behind. Again, I do apologize for that. Now, I'd like to thank you all for joining us today for an ICC YAF Africa chapter discussion about the 1958 New York Convention on the recognition and enforcement of arbitral awards. My name is Tabitha Joy Rowry. I am one of 8 ICC YAF Africa representatives. I am also based in Nairobi, Kenya. I am an advocate of the High Court of Kenya. I practice with a law firm called Anjawala and Kana. So good morning, good afternoon, and good evening from wherever you are. Joining us today are 4 individuals, if I can introduce them. First of all, we have Emile de Haas. She is a representative of Young ICCA. Now, she's a research fellow. And for those of you who don't know Young ICCA, it is a branch of the International Council for Commercial Arbitration. She supports ICCA's judicial outreach program and its New York Convention roadshows. So these roadshows are a series of trainings for national court judges on the application of the New York Convention. And it is in cooperation with ICCA's Judiciary Committee and partners across local jurisdictions. So she has organized virtual roadshows in Africa and Latin America. She's working closely with Young ICCA on a similar training program for these roadshows, and we're so glad that we have Young ICCA partnering with us today. She's also a rapporteur to ICCA's ISDS watch group on the work of UNCITRAL's Working Group 3. She is a graduate from McGill University, and she's also worked as an assistant legal counsel at the Permanent Court of Arbitration. She's a talented young lady. She speaks 3 languages, English, French, and Spanish. So you're very, very welcome, Emily. Next person I'd like to introduce is Christopher Awadimila. Christopher is the Special Assistant to the Attorney General of Delta State in Nigeria. He has a broad knowledge of arbitration and expertise in dispute resolution. He was the recipient of the prestigious Dean's Award for Excellence with respect to his contribution in advocacy at the University of Benin. He currently serves as an executive committee member to the Lagos Court of Arbitration Young Arbitrators Network. And he is one of the 4 ambassadors of arbitrator intelligence in Nigeria. Thank you so much for being with us here today, Christopher. Now, allow me to introduce Atkilit Bekelele. One second. Just a second. Sorry, guys, I want to get this right, so I've had to refer to Adkilit's profile. Adkilit is an associate at Mesfin Tafesi and Associates, which is based in Addis Ababa, Ethiopia. Mesfin and Tafesi is a member of the ALN network. She's an associate, and she was part of the litigation team that assisted in the Consta joint venture in its litigation concerning the finality of an arbitration award. She was also part of a team that assisted clients in various ICC arbitrations. She has also worked in several litigation matters, and she has an LLM from the Central European University, and there she participated in the Willem C. Vismuth team in 2020. Welcome, Articulate. Sorry about the delay in introducing you. Our final speaker of today will be James Ngodo Kariuki. James, like me, is an advocate of the High Court of Kenya. He's based in Nairobi, Kenya, and he practices with the firm of Iseme Kamau and Maema, which is part of the DLA Piper Africa Group. He is the current chairperson of the Chartered Institute of Arbitrators Kenya Branch Young Members Group. He is a fellow of the Chartered Institute of Arbitrators UK, a fellow of the Malaysian Institute of Arbitrators, and a fellow of the Arbitrators and Mediators Institute of New Zealand. He is also a certified mediator and an adjudicator with the High Court of Kenya. He holds a master's degree in international investment and trade law, specializing in cross-border investments and treaty instruments. He's also involved in several local, regional, and international arbitrations across various areas. So thank you so much, James, for being with us today. Without further ado, I would like to, go back to the program. I hope you can all see my screen. We will be taken through the discussion of the New York Convention by Emily. And thereafter, we will have country perspective from our three speakers, Christopher, Atcliffe, and James. And then we will be opening the floor for questions. Now, you should be able to type out any questions you have at any point in the chat room. So kindly feel free to engage with our speakers on the chat, and we have reserved some time for question and answers. I think at this point, I can give the floor to Young ICCA.
Thanks, Tabitha. Hi, everyone. Good afternoon. Allow me just a minute to share my screen and we'll get started.
No problem.
Great. Can everyone see?
Yes, we can see your screen. Sorry, if I can just say, I didn't say this at the beginning. All protocols observed. Guys, we are recording this meeting. And we are also going live on ICC Kenya's YouTube page. Thank you.
Perfect. So thanks, Tabitha. Hi, everyone, and good afternoon. Thank you, Tabitha, for the invitation to speak on behalf of Young ICCA. I'm honored to be giving the opening lecture before what really promises to be a great discussion with our expert panel. So I'm very much looking forward to that. I'd like to say a few words about ICCA and Young ICCA before we dive into the topic of the lecture, which is the world-famous New York Convention. So ICCA is a worldwide non-governmental organization. It was founded 60 years ago in 1961 in the middle of the Cold War to promote the use of international dispute resolution across borders and across legal cultures. So we're based at the Peace Palace in The Hague, and we work closely with the Permanent Court of Arbitration. We develop congresses, publications, and projects for the global arbitration community. Our status as a nonprofit NGO gives us the neutrality and the independence to really take up cutting-edge issues and represent many diverse viewpoints. As you'll see here on the map, we're a membership-based organization with over 1,000 members from approximately 90 countries across the globe. And our branch for young practitioners, as Tabitha mentioned, Young ICCA, was founded in 2010 and has over 8,000 members now. And the goal of Young ICCA is really to open the doors of international arbitration to a younger branch of practitioners seeking out members and activities across the globe. Young ICCA specifically has 4 key areas of activity. We have skills training workshops, the mentoring program, university scholarships, and the Young ICCA blog. So to give you an example, some of the recent online training workshops we've had included training on arbitral secretary appointments, efficient legal research strategies for international arbitration cases, and advocacy for young practitioners. You can find all of these recordings of the past events of these trainings for free on the Young ICCA website, and I definitely encourage you to check them out. We also have an essay competition going on right now for a few more days, the topic of which is confidentiality in international commercial arbitration undermines the legitimacy of the process. And of course, the writers are asked to take a position on that question. So have a look at our website if you're interested and for the deadlines. And I also encourage you all to sign up for Young ICCA, which is a free membership, and it's just a great community. Now, the presentation that I want to give today, and Tabitha loosely or closely alluded to it in her introduction, is based on ICCA's New York Convention Roadshow program. This is a judicial training program that we offer national court judges on the interpretation and the application of the New York Convention. Since 2012, we've held over 35 colloquia with national court judges all over the world. And the goal of these trainings is to promote the uniform interpretation of the convention across jurisdictions. So what I've done is that I've adapted, and you can see on the screen some of the places that ICCA has been with these trainings. What I've done is that I've adapted the content to hopefully engage a broader audience, which is all of you, and provide an overview of the convention with a few references here and there to local law, where I could find them. So here we go. Here we just have a general structure of what I intend to cover in the next 30 to 40 minutes. We won't get into too many technical questions, although there will be some, but really the idea is to provide you with a broad understanding of how it operates and why it's so important to the general framework of international arbitration. So we'll look at history and the success of the convention, general scope of application, arbitration agreements, awards, and then at the end, I'll just flag a few resources for those who are interested in learning more about the convention. So let's look at a brief history of how the convention came to be, as well as the success that it's had since its entry into force into 1958. Really, the history of the convention starts with two treaties of the 1920s, the Geneva Protocol on Arbitration Clauses and the Geneva Convention on the Execution of Foreign Arbitral Awards, both concluded under the League of Nations, which we know was the predecessor to the UN. The purpose of these treaties was to create a mechanism for the enforcement of arbitration clauses, which at the time were not enforceable, and of arbitral awards. However, after the Second World War in the 1950s, it was felt that these treaties no longer really met their purpose. So the International Chamber of Commerce, the ICC, took the initiative to develop a new convention, producing a draft in 1953 that was later picked up by the United Nations Economic and Social Council in 1955. And then there was sufficient interest in the convention across the world to convene a two-week conference in New York in 1958 under the auspices of the United Nations. And it was the Dutch delegate, Professor Peter Sanders, who was also one of ICCA's founders, who drafted and proposed a text that gained support from the other delegates and became the new structure of the convention. For this reason, Peter Sanders is kind of considered one of the founding fathers of the convention. And you can see a picture of him at the bottom of my screen here in a picture that was taken near the end of his life. Professor Sanders passed away in 2012, just 1 week after his 100th birthday. In the years after the convention, after it came into force, it became a great success. It's even been described as, I quote, perhaps the most effective instance of international legislation in the entire history of commercial law. And we can evaluate this claim according to two standards. The first is just the sheer number of contracting states. As of today, there are 169 contracting parties that have ratified the convention. As you can see on the screen, and I'm sure our speakers will mention this in their individual presentations, but you can see that Nigeria ratified the convention in the 1970s, then Kenya, and just recently Ethiopia, which is very exciting. In total, there's 42 African contracting states to the convention. And then the second standard is just looking at how the convention has been interpreted and applied by national courts in various countries, which have generally been favorable to the enforcement and to enforcement of awards and agreements, and supportive of international arbitration. Very briefly here, for those who are visual, on this slide, you can see an overview of the contracting states to the convention. The dark blue states are the ones that have adhered to the convention, and the gray ones, you can see there are very few left, are in the process or are considering joining the convention. The fact that there are so many contracting parties to the convention has been of a great benefit to the operation of international arbitration in general. This is because the convention is often referred to as the backbone of international arbitration practice. And why is this? This is because without an efficient and reliable enforcement regime, arbitral awards would be really of little value. And it's also in the interest of states to ratify the convention. A contracting state will be viewed more favorably by the international arbitration community, among others, commercial parties, because ratification of the convention signals that the jurisdiction is committed to promoting arbitration and facilitating enforcement of foreign awards in its territory. In terms of convention, the structure, the convention contains 16 articles, of which only the first 7 are relevant for our purposes. It's been translated into 5 languages, each of which is equally authentic. Here, I just put a list of the relevant 7 articles, which we'll go through one by one. I just want to provide here just a visual of how the convention, in reality, how short it is for our purposes. It's really designed to be simple in application. So the purpose of the convention is to promote international commerce and the settlement of international disputes through arbitration. It seeks to facilitate, first, the enforcement of agreements. In other words, to rely on an arbitration agreement to resolve a dispute via arbitration instead of in court. And enforcement of arbitral awards, meaning to collect on amounts owed under an award. In terms of case law statistics, there's actually about 50% of judicial decisions applying the convention to the enforcement of arbitration agreements. So here you have the two actions contemplated by the convention. Okay, let's look at its general scope of application. We'll start with Article 1.1, which provides the general scope of application as it applies to awards. So Article 1.1, the relevant part reads that this convention shall apply to the recognition and enforcement of arbitral awards made in the territory of a state other than the state where the recognition and enforcement of such awards are sought. So this article establishes the material scope and the territorial scope of application to awards. Let's look at material scope first. So the convention applies to arbitral awards, but it doesn't provide a definition of the term in its texts. So really it's up to national courts to determine whether, first, the dispute settlement procedure that resulted in the award was in fact arbitration. And for that, the court will generally look for characteristics of an arbitration, namely that the parties had an agreement to arbitrate, because we all know arbitration is a consensual process, and that there was binding resolution of the dispute, which, contrary to conciliation and mediation, for example, arbitration results in a binding determination of claims. And then second, the court will make sure that the decision before it is in fact an award. And for that, it will look at whether the decision definitively puts an end to the dispute, in whole or in part. So really the name given to the document by an arbitral tribunal, whether it's an award, an order, or decision, is irrelevant in most cases. Courts will look at its substance because an award settles the issues that it seeks to resolve and is final in nature. So that's a bit on the material scope. Let's look at the territorial scope. Once the court is satisfied that an application for the enforcement falls within the material scope of the convention, it'll look at the territorial scope. Because as we just saw, Article 1.1 applies to awards made in the territory of a state other than the state where the recognition and enforcement of such awards are sought. This means that the convention applies to arbitral awards issued in jurisdictions other than the one when the application is made. And there are two important points to make here. First, an award is generally considered to be made at the legal seat of arbitration. So for example, if the seat of an arbitration was Paris, that would be considered the jurisdiction in which the award was made for the purpose of the convention. And second, Article 1.1 precludes the convention's application to purely domestic arbitral awards. So awards that are the result of purely domestic arbitration. Now, the last thing we'll look at in terms of just general scope are the reservations. When a country ratifies the convention, it can decide to declare that it will only apply the convention, either one, if the award was made in the territory of another contracting state, as opposed to just any state in the world, or two, if the dispute arises out of a legal relationship that is considered commercial according to the law of that country. So the first reservation I just mentioned is referred to as the reciprocity reservation. The idea behind including this option in the convention was at the outset to incentivize states to become party to the convention. But these days, as we just saw on the map with all the blue countries, it's not as relevant anymore because there are already 169 states that are parties to the convention. So this means that it doesn't happen very often that an award is rendered in a country that is not already a party to the convention. And all three countries that we'll be hearing from later on from our experts have made this reservation. The second one is known as the commercial reservation. And this essentially, if a state has made this reservation, the court considering an application will need to look at whether the dispute in question arises out of a commercial context. They'll look at how the law in their jurisdiction defines commerciality, but most courts interpret that term broadly. And I think we'll hear again from our experts on this question of commerciality a little later. So that's it in terms of general scope. We'll move on now to arbitration agreements. At this point, you may have noticed that Article 1 on the general scope of application, or the title of this convention, actually, for that matter, makes no mention of arbitration agreements. This is because Article 2, that we're going to see now, was included in the draft convention back in 1958 at the very last minute. So the drafters thought that given the purpose of the convention, which is to promote the settlement of disputes by arbitration, it was essential to include a provision that would allow courts to enforce arbitration agreements in addition to awards. In practice, enforcement of an arbitration agreement means staying court proceedings or dismissing a claim in court for lack of the court's jurisdiction in favor of dispute resolution by arbitration if a valid arbitration agreement is produced. So despite the convention's silence in Article 1, its scope of application to arbitration agreements is rather similar. You see here that the obligation to order or to compel arbitration is found in Article 2.1, which states that each contracting state shall recognize an agreement in writing. So it's an obligation. Each contracting state shall recognize. So referral to arbitration, as I was just saying, is mandatory, as you can see by the first paragraph of Article 2. So if a court finds that an arbitration agreement appears prima facie valid, it must enforce it. So in other words, or in practice, that just means it has to order the parties to settle their dispute pursuant to their arbitration agreement. Broadly speaking, there are 4 requirements or issues that court will look for when considering whether to enforce an agreement. They look at whether the agreement falls within the territorial scope of the convention. In terms of formal requirements, they'll look at whether the agreement is in writing. Then they'll check whether the agreement falls within the material scope of the convention. And then they'll also check whether the agreement suffers from any defects. In other words, can the agreement be deemed valid? So the first test here, whether the agreement falls within the territorial scope. As I just mentioned, the convention is silent on territorial scope with respect to agreements. So courts will typically look for a foreign element to the agreement in order to enforce it under the convention. So the convention does not cover purely domestic arbitral agreements. And this foreign element can be found, can be that the agreement provides for the legal seat of the arbitration in another jurisdiction, that the agreement is deemed international because of the nationality or the domicile of the parties, or that there's some foreign element to the underlying transaction. Then a party must show that the arbitration agreement is in writing. And the source of this obligation is found in Articles 2.1 and 2.2. And the term agreement in writing can include an arbitral clause in a contract or an arbitration agreement signed by the parties or contained in an exchange of letters or telegrams, as we can see in Article 2.2. Now, I don't know who uses telegrams these days, but if they do, they sound great. But for us normal people, thankfully, other means of communication have been accepted by courts to fulfill this writing requirement. So the first option is to show an arbitral clause in a contract or an arbitration agreement signed by the parties. And then, as I mentioned, the second option is for the agreement to be in writing, contained in an exchange of letters or telegrams. But these days, the provision is expanded or is interpreted expansively, meaning that the examples listed above or here are not exhaustive. So, for example, and thankfully, email communication today is widely accepted as evidence of the in writing formal requirement. Moving on now to material scope, courts will look at whether the agreement falls within the material scope of the convention, and for that, they need to be convinced that the parties consented to arbitration, there's an agreement, and that the parties to the dispute are the same ones that are the ones that consented to arbitration. So in other words, an agreement is only binding on the parties who concluded it. Third parties are typically theoretically excluded and can't be compelled to go to arbitration, but there are some contractual law theories that can bring in third parties sometimes, but I won't go into that for our purposes today. They'll also look at whether the dispute falls within the scope of the arbitration agreement. And for this, the court will determine whether it can be reasonably inferred that the parties intended for the dispute in question to be included or excluded from arbitral jurisdiction. And then they'll look at whether the subject matter of the dispute is arbitrable. So in other words, is the subject matter capable of settlement by arbitration, usually according to the law of that forum. Now, the last thing on arbitration agreements is that referral to arbitration is mandatory. So the text of Article 2.3 clearly states that the court shall refer the parties to arbitration. So it's important to recognize here that courts have no discretionary power as to whether to order arbitration, except if one of the 3 exceptions listed here is proven by the party resisting enforcement of the agreement. So they can either argue that the agreement is null and void, which just means that the arbitration agreement was invalid from the outset, either because it was concluded by fraud, illegality, or mistake, that it's inoperative meaning that the agreement was valid at one point, but it has ceased to have effect, or that it's just incapable of being performed, which means that the arbitration can't proceed due to a legal impediment. And this usually means a pathological clause. So a clause that's poorly drafted and can't be interpreted or enforced by the courts. So to wrap up on Article 2, Article 2 creates a presumption of validity. So an agreement is presumed valid unless it's found to be null and void, inoperative, or incapable of being performed. And referral is mandatory. So the convention didn't intend here to leave any discretion to national courts on this. Okay. So we've made it to our last substantive portion of the presentation, which we will look at now, which is the enforcement of foreign arbitral awards. Before we go any further, let me just briefly explain what enforcement means in the context of awards. When it comes to awards, enforcement is the process through which the winning party in an arbitration requests a court to execute or to carry out its arbitral awards. So in other words, it's asking a court to apply legal sanctions to compel the losing party, the award debtor, to carry out its obligations under the award. In most cases, to pay up. So a party can seek leave to enforce only in a particular jurisdiction, and it has no effect in other jurisdictions. What this means in practical terms is that to enforce an award in more than one jurisdiction, if the award debtor has assets in multiple places, you have to go through enforcement procedures in every one of them. Enforcement here, or for that matter, the objection to the enforcement of an award, is not to be confused with setting aside an award. Setting aside proceedings are different. Most of you probably know this already, but just so we're on the same page, they take place when a party disagrees fundamentally with the award and it wants the court at the seat of arbitration. Note here, not the jurisdiction in which it's looking to enforce the award. This is different. So the court at the seat of arbitration to declare that the award is null and void, or in other words, to set it aside, to annul it. In most legal systems, the result of this action is that the award is invalidated and it no longer exists. In most jurisdictions, but there are exceptions. So a setting aside action can only be filed in the country in which the award was made, so at the seat of arbitration, and no other court has jurisdiction over setting aside procedures, in contrast to enforcement procedures. And I think sometimes the confusion here comes from the fact that the grounds to set aside an award that you find in national arbitration laws and the grounds to deny enforcement are often very similar. And the reason why I'm raising this now is because setting aside procedures are relevant here in that once the award has been set aside at the seat, most jurisdictions won't enforce it. Although, as I mentioned, this is contested and there are just some jurisdictions that do. It's hotly debated. I was able to find a Kenyan case law here in which this distinction is summarized. Here, two parties arbitrated a dispute pursuant to a contract that contained an arbitration clause, providing for resolution of the dispute in Nigeria, and it was governed by Nigerian law. The winning party sought to enforce the award in Kenya before the Kenyan courts, and the losing party objected to the enforcement of the award in Kenya and applied to the court there to set aside the award. And the High Court of Kenya in Nairobi found that it lacked jurisdiction to set aside the award because only the courts at the seat of arbitration, so here, Lagos, had primary jurisdiction to set aside the award. Now, had the arbitration been seated in Kenya, the Kenyan arbitration law would have applied, and then Kenyan courts would have been competent to set aside the award. So you see here in this case, the Kenyan courts making that distinction. All right, with that out of the way, let's look at Article 3. Article 3 introduces the obligation on contracting states to recognize arbitral awards as binding and enforce them according to the conditions in the following two articles, Articles 4 and 5. The only thing to mention here with this article is that enforcement is done in accordance with the rules of procedure of the territory where the award is relied upon, and that such rules shall not be substantially more onerous than the rules of procedure imposed on the recognition and enforcement of domestic awards in that jurisdiction. So we'll hear from our experts soon from Nigeria, Kenya, and Ethiopia on the rules of procedure in their respective jurisdictions. But from what I was able to gather in preparing for these talks, the rules of procedure in all three seem to align quite closely with the convention and the institutional model law. Next, we have Article 4. Article 4 is basically putting together the conditions for enforcement of an award. It essentially indicates the two documents that the applicant must submit to court to obtain enforcement of his or her award. And these are very simple: a copy of the award and a copy of the original arbitration agreement, and possibly a translation of that agreement if necessary. So as you can see, if you're the counsel for the party seeking enforcement of the award, your job, at least at first, is relatively easy. You have to provide the court with the award and the original arbitration agreement. They have to be duly authenticated or a certified copy. And in practice, authentication just means that the signature on the document are attested to be true from the persons who have signed it. And a certified copy, that can be ascertained by an arbitral institution or another authority that can verify or can certify an arbitral award. So in essence, if a party has submitted these two documents in due form, it's prima facie entitled to leave for enforcement. It can only be denied if one of the grounds in Article 5 are proven by the party resisting enforcement. So we'll look at these now. So Article 5 of the Convention sets out the grounds to deny enforcement. Some consider this article really to be the heart of the Convention. So denial of enforcement can only be allowed if one of the grounds contained here in Article 5 are present. And it's important to note that these grounds are exhaustive. Article 5 is divided into two paragraphs. Paragraph 1 contains the grounds for refusal that must be proven by the respondent. And what Article 5 does here is it's really all about the protection of the respondent's right to due process. So according to the first ground, the respondent can argue that the incapacity of a party to the arbitration agreement, or that the arbitration agreement pursuant to which the arbitration took place was invalid. Under the second ground, it can be argued that due process has been violated by showing that the respondent was not given proper notice of the appointment of an arbitrator or of the proceedings, or was otherwise unable to present its case. So in other words, its due process rights were violated. Pursuant to the third ground, the respondent can submit that the arbitral tribunal exceeded its authority in deciding the case. And in practice, what this means is that the arbitrators rendered a decision on issues that fell outside the scope of the arbitration agreement. So in other words, the tribunal went beyond the mandate given to it by the parties in their arbitration clause. Enforcement can also be denied under the fourth ground if there was irregularity in the constitution of the arbitral tribunal or the arbitral procedure. What this means in practice is that an award may not be enforced if the procedure by which an arbitrator was appointed didn't follow the agreement of the parties, or when a procedural decision goes against the arbitration agreement, such as when the tribunal fails to apply the procedural law determined by the parties in their agreement. And finally, the fifth ground can be invoked here when the award has not yet become binding on the parties, or, as we have seen before, the award has been set aside or suspended at the seat of arbitration. Let's look at Article 5.2 here. Paragraph 2 of Article 5 contains the public policy and the arbitrability exceptions that the court can raise on its own motion. And in essence, what Article 5.2 does is that it protects the state's notions of sovereignty by enabling its courts to deny enforcement of an award if it would violate basic notions of public policy. So we have here the first ground, it's lack of arbitrability, means that the subject matter of the arbitration isn't capable of settlement by arbitration. In other words, this means that according to the law of the enforcing jurisdiction, the subject matter of the dispute can only be reserved for courts. And typical examples of this are criminal law cases, divorce and custody of children, bankruptcy, etc. And then the second ground, ground B, most exciting, a court can deny enforcement if the award is contrary to public policy. But the question here is which public policy? Courts generally apply international public policy as opposed to their own domestic public policy. International public policy is narrower in scope, meaning that for an award to violate international public policy, it must meet a very high bar. And the general rule is that only fraudulent, oppressive, or scandalous, or in other words, awards that offend the fundamental notions of morality and justice will be denied enforcement. On the flip side, domestic public policy might include any kind of government policy, national policy on foreign affairs, or even tribal or religious law. And an award that could violate such domestic policy in that country may not necessarily rise to a violation of international public policy. So courts with a pro-arbitration stance usually favor the latter standard in the spirit of contributing to the harmonization of standards for enforcement of awards worldwide. Otherwise, awards would be denied enforcement in different jurisdictions for a wide variety of domestic public policy concerns, and this would lead to the fragmented application of the convention. Here again, Kenya, we have some Kenyan case law that is illustrative in terms of how Kenyan courts can deny the enforcement of an award on the grounds of public policy. They'll look essentially at the award if it's inconsistent with the laws of Kenya, if it's inimical to the national interest of Kenya, or contrary to justice and morality. So I'll let our Kenyan expert speak more to this if he wishes later on, but I wanted to provide a bit of case law from the region on this. Now, to summarize, some of the important features of Article 5 are as follows. First, the grounds for refusal of enforcement are limited to those identified in the text, so they're exhaustive, as I mentioned earlier. Second, courts may not review cases on the merits of the award. That function has been granted to the arbitral tribunal by the parties' agreement to arbitrate. So courts are only here to supervise the arbitral process and to ensure that due process has been upheld. Third, the burden of proof is on the party resisting enforcement, and it's a high burden. For example, a respondent may be prevented from objecting to enforcement successfully if she or he didn't raise the objection during the arbitration, such as the invalidity of the arbitration agreement or a violation of its right to be heard, and so on. And finally, it's important to note that courts usually apply a narrow interpretation of the grounds for refusal. This means that they don't easily accept that a ground for refusal has been met. And the general rule for a successful objection on the basis of Article 5 is that it must be serious enough to potentially have had an impact on the final outcome of the arbitration. So in other words, the outcome of the arbitration may have been different if the alleged violation of the respondent's procedural rights otherwise hadn't occurred. And the result of this is that objecting to enforcement on the basis of Article 5 is rarely successful. Statistically, courts refuse enforcement in only about 10% of cases. And the number of cases brought to courts for enforcement already represents some 10% of the total number of arbitral awards issued. So you can see that it's very rare for enforcement to be denied. So there you have it on Article 5. The last provision I just want to address briefly is Article 7.1, which is referred to as the more favorable right provision. The full article is quoted on the slide, but the relevant portion is the following. The provisions of the convention shall not deprive any interested party of any right it may have to avail itself of an arbitral award in the manner and to the extent allowed by the law or the treaties of the country where such award is sought to be relied upon. So Article 7.1 addresses the relationship between the convention and national laws or treaties that also deal with the enforcement of awards in the forum where enforcement is requested. Most often, this is the Arbitration Act enforced in that jurisdiction. So it allows a party seeking recognition and enforcement to rely on rules that are more favorable than those of the convention. And they may be more favorable in terms of imposing less demanding procedure or more expansive grounds to deny enforcement. And the rationale behind this provision is that the purpose of the convention is to facilitate the enforcement of foreign arbitral awards, full stop. So by including the more favorable right provision in Article 7.1, if a party seeks to rely on another more favorable legal basis, the convention may give way to that other basis. Okay, so we've made it to the end of the substantive portion of the lecture. Thank you so much for your attention so far. I hope it was a good introduction, or maybe for some, a good refresher on the New York Convention. Before we hear from the other speakers, though, I do want to draw your attention to a few tools that could help you in learning more about the convention if you're interested. And of course, regardless of where you are in your studies or in your practice. To your left, or at least to my left on my screen, you have the Young ICCA, the Guide to the Interpretation of the 1958 New York Convention. This is an article-by-article guide to the convention, available for free on our website in 27 languages. And I'll share the link to the guide, to the PDF in the chat later on. In the center, you have the UNCITRAL Secretariat's Guide on the New York Convention, which is also a useful guide in terms of article-by-article analysis. And the orange book to your right, or my right, is the ICCA Yearbook Commercial Arbitration. This is a useful publication if you're looking for national court decisions on the interpretation of the convention. It's available on kluverarbitration.com, and you can filter your search for cases either by jurisdiction or by convention article. It has over 3,000 published court decisions from over 100 jurisdictions dating back to 1976. So for example, I was able to look at decisions from Nigeria and Kenya published in the yearbook to prepare for this lecture. And as soon as case law is developed in Ethiopia on the interpretation of the convention, I'm sure that it'll make its way into the yearbook as well. On this slide, you have the ICCA Handbook on Commercial Arbitration, and this is where you go if you're looking for a general overview of the practice of arbitration in a specific jurisdiction. So the handbook covers over 80 countries, and each country report has a section on enforcement of awards in that given jurisdiction, but it also covers all aspects of arbitration in that country. In the center, you have Lisa Bosman, who's the executive director of ICCA. Her new book, Arbitration in Africa, A Practitioner's Guide, published in September of 2021. And this has the most up-to-date information on the practice of arbitration, and it covers 49 African states. It also has regional chapters on the arbitral trends in different regions in Africa, and a very comprehensive part or section on investment arbitration in Africa as well. So I encourage you to consult it if you can. And finally, make sure you have a look at Young ICCA's webinar series that I mentioned at the beginning. They offer training workshops and interviews with arbitration experts. There's one webinar in particular that addresses the post-award phase of an arbitration, including enforcement. That might be interesting for our purposes. And again, I'll share the links with the organizers after this. So in conclusion, I'd like to make these two final remarks. The first is that notwithstanding what you have heard so far today, and the possible impression that it may be a little complicated, the New York Convention is simple in design and it's intended to be easy in application. And the second point is that it's in the interest for everyone, or it's in the interest of everyone, for the convention to be interpreted and applied in a harmonized way across all jurisdictions. So for commercial parties and users of the system, a harmonious interpretation creates predictability and confidence in international dispute resolution in arbitration. And for practitioners, it makes our lives easier if we can rely on solid and consistent precedent and advise our clients accordingly. So I encourage you, wherever you are in your careers, to learn more about the convention so that when the time comes, you're familiar with the way it works and you can advocate for its application in line with the common goal of harmonization. So I will stop sharing my screen now. Thank you so much for your attention. And I look forward to our Q&A section of the event. But for the moment, I'd like to invite Chris to take the floor and give us a bit of an overview on the enforcement regime in Nigeria. Thank you. Chris, the floor is yours.
Yeah, thank you very much. I say it was a very, very nice experience listening to your presentation. I learned a lot. So I want to share my screen. Can you see my screen? Hello, can you hear me?
Yes, we can see it. Thanks.
You can see my screen. Okay, so good day, everyone. Christopher, so I'll just be brief. I have just 10 minutes to speak before I yield the floor to the next panelist. So it's quite interesting. As Emily stated, the New York Convention was, acceded to in 1970, and it also became, it came into force on the 15th of June of that same year. Currently in Nigeria, our extant law is the Arbitration and Conciliation Act. It's a 1988 act, but nevertheless, it still reflects some current practice in the arbitration community. And given the fact that Nigeria is also a federating, we operate the federal structure here. The federating states also have their respective arbitration laws. Like we have the Lagos State Arbitration Law of 2009 and also the Rivers State Arbitration Law of 2019. Both of these laws reflect are modeled after the 2006 version of the UNCITRAL model law. And the Arbitration and Conciliation Act is modeled after the 1985 version. So just as a background and to give available data on arbitration in Nigeria, you see from my screen that there's this research that was part of where we actually looked at arbitration-related decisions in Nigeria, we collected a lot of them and did a quick research on them in our firm. And from there, we could see that 74% of the times the court refused to set aside. 80% of the time, the court enforced arbitral awards, while 31% of the time the court granted stay of proceedings applications. While you might be wondering that why is the percentage of successful applications for stay, why is it so low? Subsequently, while I speak to my slides, you
Chris, I think are you with us? I think we lost
you. Lost me. I think I'm having an Yes, sorry for that. Can you hear me now?
Yeah, it's coming
Can you hear
through.
me now? Is it better?
It's better. Let's see how it goes. I'll let you know if you break up again.
Can I proceed?
Yes, please go
Okay.
ahead.
Probably if I break up again, I might just have to stop my video to reduce the bandwidth. Warning me again that I have an unstable network. So let me just do that right away. Yeah, so as you can still see my screen, right?
Yes.
Okay. So I said subsequently, I'll actually explain why the courts it appears that courts are not really granting, stay of proceedings applications, but indeed, most times we see that the court is left with no option but to just refuse to grant applications for stay of proceedings. So for the purpose of this presentation, I will only focus on the enforcement of arbitration agreements, which is, as Emily has stated, is contained in the new. I would really not say a lot or nothing about challenge applications for want of time. So primarily, Section 125 of the Arbitration and Conciliation Act deals with definition and also the enforcement of arbitration agreements. For stay of proceedings, particularly, we have it in Section 4 and 5 of the Arbitration and Conciliation Act. And the provisions are quite similar to the New York Convention, to the extent that it appears that Section 4 and 5 of the Arbitration and Conciliation Act kind of gives the Nigerian courts, the discretion rather than an obligation to enforce arbitration agreements. But the Nigerian courts judiciary, the attitude so far from case law shows that the court sees it as an obligation, as mandatory, as far as you meet up with the provisions or the requirements for stay. So once an applicant is able to show that there's an enforceable arbitration agreement, then courts in Nigeria will definitely honor the agreement of the parties and enforce the arbitration agreement. Then secondly, it's also important to note that Nigerian courts have also adopted a liberal approach to the construction of arbitration agreements. So I said there's a case here, Mekunya and Mukwe, it's actually a leading authority in Nigeria, where the Nigerian Supreme Court actually enforced or resolved, stated that a particular arbitration agreement was not pathological. It's actually, I think the case is very popular because in that, the parties actually, the arbitration agreement stated that parties would submit their dispute to the Chartered Institute of Arbitration, London, Nigerian chapter. And there's nothing like that. It's what we have is Chartered Institute of Arbitrators, UK, Nigerian chapter or Nigerian branch. So the court had to say, no, what the parties actually meant here is not to refer their dispute to a non-existent body, but rather to say to the Chartered Institute of Arbitrators, the United Kingdom. So this just shows that Nigerian courts are actually, pro arbitration, and at every given time they want to enforce arbitration agreements and awards. So as it relates to, like I stated, earlier on my slide, you see that 31% of the time, that's only when the court enforced arbitration agreement or allowed stay of proceedings. But from what we found out, you see that a lot of times it's actually not, the court's hand is actually tied. For instance, some of the recurring reasons why the court refused to stay application is because the application was brought after judgment was delivered at the High Court, like at the trial court. So it was more like an afterthought, and that's taking steps in proceedings, which almost in all jurisdictions, once a party has taken steps, you can actually waive your right to arbitration. So if you've done that, the court will not enforce your arbitration agreement. But despite that, we also still found a decision where the court, after parties had filed their pleadings and taken steps in the proceedings, the parties came together and said, please refer us to arbitration. And the court actually referred them to arbitration. And subsequently, they came back to court and enforced the award, and the court actually granted it. So another recurring reason is that we see situations where the other party to the proceeding was not a signatory. And also the dispute did not fall within the scope of the arbitration agreement. You see that most of these grounds are also reflected in the New York Convention. Like the subject matter was not arbitrable, then the dispute clause continued jurisdictional clause. Now, this one is kind of dicey because I know that in some jurisdictions like Singapore, even if you have your jurisdictional clause, sometimes the courts always try to. Can you hear me?
Yeah,
okay.
We can hear you.
Yeah, thank you. The court always tries to resolve or there's a pro-arbitration, approach. But then in Nigeria, if you have a jurisdictional clause where you also grant exclusive jurisdiction to the court will not enforce your arbitration agreement in that instance. So moving on to the second part of my presentation on enforcement of awards. So the Arbitration and Conciliation Act in Nigeria is actually split in two. We have we have the first part, in three, in fact, into three parts. We have the first part that deals with domestic arbitration. We have another part that deals with conciliation. Then the final part that deals with international arbitration. So for enforcement of domestic arbitration awards in Nigeria, you refer to Section 31, while for international awards is Section 51. But primarily the provisions of those two sections reflect the criteria in the New York Convention. You only need to supply the court with your duly authenticated original award and the arbitration agreement or the certified copy of any of them. So to that extent, we still practice here still reflects the the criteria in the New York Convention. Then I found this case very interesting, and I think I should bring it to our attention. So there was this Sunderland and Milan Nigerian Limited. In this case, the court actually kind of introduced a new practice, like conditionally enforcing an award. So the Court of Appeal here did something that was quite interesting, in the sense that parties had not complied with the strict provisions of Section 51. It was even an international award to be enforced. And the court said, the fact that you did not provide the duly authenticated copy of your award, I will enforce this award, subject to the fact that subsequently you come back and supply the copy to the court. So at the trial court, the award therefore actually was dissatisfied and appealed to the Court of Appeal, but the Court of Appeal still upheld the decision. And so right now, until the Supreme Court says otherwise, this is the law in Nigeria. So then, even if, as I stated, as contained in my slide earlier, we have 80% of the time the courts, are prone to, enforcing an arbitral award. What's the account? I mean, you want to ask what of the remaining 20%? Why will the court still refuse to, enforce an award in Nigeria? So these are some of the reasons that we found. So in an instance where the arbitrator was appointed contrary to the agreement of parties, then the court will not enforce the award, or a party was not given due notice of arbitral proceedings. That goes to the breach of natural justice and the root of the arbitration itself. So then we also had instances where the arbitrator excluded vital evidence which would have affected the conclusions in the award. So in that instance, the court would also say, no, we're not going to enforce this award. Then the arbitrator went beyond the scope of submission to arbitration. That's quite different from going beyond the scope of the arbitration agreement itself. So the submission to arbitration is what the pleadings or what parties are submitted before the arbitrator. So regardless of the fact that probably the matter was even within the arbitration agreement or within the scope of the arbitration agreement, as far as it was not within the scope of submission to arbitration, then in that instance, the court will not enforce it. And most of these grounds also reflect, current practice in the international arbitration community. So that's it from my end. I hope I didn't did I use 10 minutes? So that's if there are further questions I will oblige, to answer that during the Q&A section. So thank you very much. Over to you, Emily.
Thanks, Chris. If you just want to, great. Thank you. That was a very good overview. I took some notes, and we might have some follow-up questions for you in a little bit when we've heard from the other speakers. And I encourage the attendees also to post their questions in the Q&A. If you want to answer some in written form as well, Chris, that'd be great. I'd like to invite now our expert from Ethiopia. We have Atkilet online, and very much looking forward to hearing about Ethiopia and its recent ratification of the New York Convention, and how it might change the landscape of arbitration in Ethiopia. So Atkilet, the floor is yours. Thanks.
Thank you, Emily. Good afternoon, everyone. And thank you for attending this webinar. And also thank you for Tabiti for inviting me and to talk about the experience of Ethiopia in relation to the New York Convention. My network is not stable, so I'm gonna stop the video, but let me know if I break at any time. Next slide. No, the previous one. Yes. As Emily touched upon her presentation, out of the 3 countries that are represented in this webinar, Ethiopia is the last country to ratify the New York Convention, and it took place in March 13, 2020. Actually, Ethiopia signed the New York Convention about 59 years ago, but failed to ratify it until now. And the ratification came into place as a result of the country's doing business initiative. So far, there is no reported case based on the New York Convention. And due to this, our discussion will revolve around the challenges parties were facing prior to the ratification of the New York Convention. And we'll discuss what parties should expect now that Ethiopia has ratified the New York Convention. Next slide. Prior to 2020, the Civil Code of Ethiopia, which has a total of around 24 articles in relation to arbitration, and the Civil Procedure Code were the main piece of legislation that governed the recognition and enforcement of foreign arbitration award.
Have we lost you at Kile?
Oh, next slide.
Great.
Under the Civil Procedure Code, there are different requirements in order to enforce foreign arbitration award. And one of the main requirements, which was a point of contention, was the requirement of reciprocity. This was because the Civil Procedure Code does not define what constitutes reciprocity, and there was an ongoing debate whether the court should assume the existence of reciprocity. In terms of international arbitration, there was no reported case, but in relation to enforcement of foreign judiciary, there are 2 cases where the court provided an interpretation as to what constitutes reciprocity. One of the cases is the Paulos Papas case, and the other is the Mikhail and the Kenyatta case, where the court stated that reciprocity should not be assumed, and it should be proved through a judicial assistance treaty. The main problem on this interpretation is that Ethiopia only has a judicial assistance treaty with China, and even if these 2 cases involve foreign judgments, the court might extend this interpretation when a foreign arbitration award came into enforcement. So this has been a ground of uncertainty. Next slide. The other challenge parties were facing was the power of the cassation bench of the Federal Supreme Court. In general, the cassation bench has a power to review final decision on the ground of error of law. And there were a few arguments whether this power of the cassation bench can extend to arbitration awards. And the cassation bench in 2 cases has given 2 different decisions in terms of its power to review international arbitration award. The first one is the Ethiopian Djibouti Railway Corporation versus the Consta joint venture case, which was decided in 2018, where the cassation bench stated that it has the power to review the arbitration award, even if the parties stated that the decision of the arbitration tribunal is final and binding. And based on this, the cassation bench went and reviewed the arbitration award and decided that there is an error of law. And the second case was the Agricom International versus the Ethiopian Trading Business Corporation, which was decided in 2019. And in this case, the cassation bench declined to review the arbitration award, stating that given the fact that the venue of the arbitration was in London, it does not have the power to review the arbitration award. Next slide. Coming back to the current state of things, when Ethiopia ratified the New York Convention in 2020, one of the actions it took was placing the Arbitration and Conciliation Proclamation, which was a comprehensive law, and it replaced the provisions of the Civil Code, which were very scattered. And while ratifying the New York Convention, Ethiopia has made 2 declarations. One is reciprocity, and the other one is the commerciality. And the Arbitration Proclamation provides lists down matters which it thinks are commercial in nature. And currently there is ongoing argument that this list is very narrow, and in the future we might have cases based on this. Next slide. And in addition to the 2 declarations, Ethiopia has made a reservation. The reservation is that the convention will only apply in respect to arbitration agreements concluded and arbitration awards rendered after the date of Ethiopia's accession to the convention. So basically this excludes arbitration awards based on arbitration agreements entered before March 2020. And currently we are seeing amendments to arbitration clauses in order to fit into this requirement. And how Ethiopian courts as the stage of enforcement will entertain this sort of amendment will be seen in the future. Next slide. And in terms of the procedure, it's the Federal High Court which is empowered to recognize and enforce foreign arbitration agreements and foreign arbitration award. In terms of arbitration agreement, our arbitration agreement is required to be in writing and has to be attested by 2 witnesses. And arbitration agreements in electronic form are also recognized. One thing to note under here is that if the dispute is submitted to the court before the submission of submission to arbitration, the parties are required to submit a preliminary objection so that the court dismisses the case. If the parties fail to raise this as a preliminary objection, the arbitration agreement will be null and void. And during the enforcement proceeding, the parties are required to provide a translated arbitration agreement as the working language of the court is Amharic. And in terms of the arbitration award, for the enforcement proceeding, it has to be the parties are required to submit an authenticated and translated arbitration award. Next slide. This would be our last slide. And in terms of grounds to refuse recognition and enforcement of arbitration award, the arbitration proclamation and Article 5 of the New York Convention are similar. It is worth noting that the arbitration proclamation lists down non-arbitrable matters under Ethiopian law, and this includes administrative contracts. In Ethiopia, administrative contracts are those contracts signed with a public entity. So unless the public entity obtain permission in the form of law, for example, through their establishment, they cannot submit their dispute to arbitration. There is a special law, for example, the Public-Private Partnership Proclamation allows contracting states to agree to submit their dispute with the private party to an arbitration. So this sort of permissions are required for public entities to be a party to arbitration. Another non-arbitrable matter is land issues, including lease agreements with the government. Another one is administrative disputes, which for mention under this would be the list provided under the arbitration proclamation in relation to non-arbitrable matters is not exhaustive, and it's an illustrative list which gives the government to add to the list in the future dates. And this is the last slide, so I will wait for the participants to raise any questions they may have on this.
Super. Thank you so much, Achilles, for your presentation. Again, I was taking notes, many interesting points that I hope we can revisit in the Q&A. Before we do so, though, I'd like to welcome James, who is our Kenyan expert, our last jurisdiction-specific segment of the webinar before we go to Q&A. And as always, please keep posting your questions in the chat. This is great. And anyone who wants to reply to them amongst our speakers, please go ahead. So thank you, James. Welcome. And we can't wait to hear from you. The floor is yours.
Thank you. And fantastic presentation so far. Thank you, Christopher. Thank you, Achilles. Thank you, Emily, for those robust presentations. I believe what I am to present and what I'm going to offer everyone before, or rather everyone in this chat today, is more or less a Kenyan perspective. As you've seen and as you've heard from everyone else, it's more of not repetition really, but it's more of the general principles that have been picked from the New York Convention and have just been applied in each and every country with maybe one or two subjective elements. So my presentation is going to be similar, and if you just give me a moment, let me project my screen. All right, can you all see my screen?
Yes, thanks. We see it, James.
All right, fantastic. All right, so I'll just dive in. So my structure is straightforward. What I've noticed, or what I'm going to do throughout the presentation is, it's more or less going to be an introduction, or rather, I'm going to just point out how the New York Convention, first of all, the basis, as my previous presenters have already done, how it applies in Kenya. I'm also going to identify a few cases which are very pertinent, specifically with regard to enforcement, recognition and enforcement of foreign arbitral awards in Kenya. And of course, I'm going to give my 2 cents on the Kenya's position, or rather Kenya's position with regard to that. So first things first, a bit of background. Our law, of course, is also predicated, and our law, by that I mean the Arbitration Act 1995, which is the current applicable law governing arbitration in Kenya, as amended in 2009. So that's applicable law, and that specific law has more or less been substantially borrowed from the UNCITRAL model arbitral law, or rather the UNCITRAL model law, as commonly referred. And basically, what Kenya has done, as opposed to more of a regurgitation of said rules, it's borrowed substantially because ideally, as I think Emily mentioned at some point, the international approach to arbitration is not that different when it comes to individual application in every single state, save for a few elements, and as you glazed over, such as public policy and what each country would consider public policy. So I also wanted to point out that Kenya has a robust institutional framework supporting arbitration in Kenya. So not only do we have proper substantive law governing arbitration in Kenya, we have mobilized institutions. And as Christopher mentioned, there is also a Chartered Institute of Arbitrators branch in Kenya. We also have our Nairobi Center for International Arbitration, which is our localized regional and international arbitration hub based in Nairobi. And because of these institutions, of course, I think it has not only led to more arbitration references, so to speak, within the jurisdiction, but it has also had a significant effect with respect to international arbitration, and of course, which stems into the recognition of foreign arbitration or foreign arbitral awards. So the first port of call is when the applicability of the New York Convention commenced in Kenya, and that would be 10th of February 1989. I had initially done a segment on pre-ratification. However, since the discussion is on the New York Convention, I will stick to my guns with that respect due to limitations on time. However, I'll be willing to deal with any other context in that regard if we have supplemental time. So I'll move on swiftly to the meat of my presentation, which is the applicability of the New York Convention in Kenya. Now, under the New York Convention, of course, the person, and I think this is just general or generally speaking, because it's straight from the New York Convention itself, it's the burden of the person who seeks the recognition and enforcement to more or less prove or to satisfy the grounds for its recognition and enforcement in the foreign jurisdiction. Now, an arbitral award, of course, is recognized as binding regardless of the state it's made, but on application to the High Court, a domestic arbitral award would be enforced in accordance to Section 36 of the Arbitration Act 1995. So I'm starting off with domestic. I know that's not what we're talking about, but I would like to point out a few stark differences when it comes to application on domestic awards and how we treat international awards in terms of their recognition and enforcement. Lastly, in terms of this is a brief introduction, of course, an international arbitration award can be recognized as binding and enforced in accordance with the provisions of the New York Convention or any other convention to which Kenya is a signatory. Any party may apply for enforcement on an arbitral award, but often the application for enforcement is made by a party in whose favor the application award was made, and the other party will reply to this application. This was aptly pointed out by Emily in her presentation, if I recall, and this is basically a very procedural step, but it's also one that is aptly represented in the Kenyan jurisdiction. Now, the substantive provisions, and I've hinted to one of them, is Section 36 and Section 37. Now, Section 36 is a mirror of the New York Convention in the sense that what can be considered in terms of the procedure for applying to recognize an arbitral award in foreign jurisdiction is completely the same. We have more or less lifted almost verbatim the procedure set out in the New York Convention. However, more interestingly to note is Section 37, which I think now has to deal with the grounds in which one or Kenya, so to speak, in this context, may refuse to enforce or rather to recognize and enforce an arbitral award. Now, this will sound like parroting in this, I feel like it'll just sound like repetition, but it is what it is, in the sense that we have more or less replicated the provisions of the New York Convention. And for starters, you can see A over there, that the party to the agreement was, or rather one of the grounds for refusal for enforcement, recognition and enforcement of foreign arbitral awards is that the party to the agreement was under incapacity. Now, this is, of course, as you've noticed, just at the risk of not deviating from what we're talking about, most of these will also apply in terms of an application to set aside an award, seeing that it touches on fundamental party rights that have to do with impartiality, and that equal justice was accorded within the conduct of the arbitration. But we're talking about enforcement. So for starters, that's how we start. Sorry, it'll just repeat here. I've already mentioned this one. So the party to the agreement was under some capacity, that the arbitration agreement was not valid under the applicable law, that proper notice of appointment of arbitral award was not given to the party, or otherwise the party was unable to present his case. The award does not fall within or is incurably beyond the scope of reference of the arbitration, and that the composition of the arbitral tribunal was not as per the parties' agreement. Where proof is furnished that an arbitral award has not yet become binding on the parties or has been set aside or suspended, is also a ground for refusal to enforce an award for said period. Now, the last of the obvious ones, which replicate what is stated in the New York Convention, is the making of the arbitral award was, or rather, this is an interesting one, but it's straightforward, that the making of the arbitral award was induced or affected by fraud, bribery, corruption, and undue influence. So our courts have strictly interpreted this and has more or less alluded to very limited definitions of what these are. However, for the first one, fraud, this has been, I don't want to use the word abused, but fraud can be fraud can manifest in quite a number of ways. And we've seen a lot of, or rather substantial jurisprudence where fraud has been alleged, and fraud has to be more or less clear-cut. So fraud is one of the more popular avenues, often used for setting aside an arbitral award, since these provisions mirror our provisions for as grounds for setting aside an arbitral award. However, we've not seen as much application when it comes to the enforcement, recognition and enforcement of foreign arbitral awards. However, we note that the courts will treat it just the same in terms of its interpretation of fraud, bribery, corruption, and undue influence. Now, there's an additional provision just right below, because what I'm describing is Section 37 of the Arbitration Act 1995. And right after paragraph G, it also includes, if the High Court finds that, 1, the subject matter of the dispute is not capable of settlement by arbitration under the law of Kenya. And that means, and I remember Emily was pointing out as she was moving through the provisions of the New York Convention, that the applicability of the rules of the local jurisdiction also are considered when it comes to, so to speak, the applicability of the New York Convention. So in Kenya, this is one of said provisions, because it has to be in tandem with the laws of Kenya and cannot deviate from what would be considered as a law applicable within the jurisdiction, and the jurisdiction being Kenya. Secondly, and more controversially, the recognition and enforcement of an arbitral award would be contrary to public policy of Kenya. And thank you very much, Emily, for pointing out the case that you highlighted, because that's a crux, or rather that's also the point of reference within our jurisdiction for what is considered, or how the courts have interpreted, what public policy is in terms of what, or the scope of public policy. However, you will have noticed from that said definition, and just for clarity, I'm referring to the Christ of All Nationals versus Apollo Insurance. That's the case that I'm referring to. That was aptly mentioned by Emily in her presentation. Now, in that case, it may seem like a scope has been defined. And I haven't quoted it here, But just for the purpose of not trying to go in deep into this rabbit hole called public policy, that will be very difficult to get out of, it doesn't really give a solid wall boundary definition. It's not within a box as to what public policy is. However, as Emily pointed out, it moves towards the direction of an international interpretation of public policy, albeit recognized locally through this case. So to speak, what Kenya has done, it has more or less taken that international approach and localized it and crystallized it into, for example, this case, because of course, precedent is, local precedent is local law, so to speak. So it is also domestic public policy when the scope that has been defined in the Christ of All Nationals versus Uphold Insurance, that is the interpretation that the courts will take. And you'll note from that case that the grounds that have been pointed out and what is considered public policy is usually around the general aspects of administration of justice. And it's usually when a party is impeded or when a due procedure has not been followed, and other pertinent factors that may affect the validity of the eventual award that may affect, of course, its recognition and enforcement. So moving on swiftly, and I'm glad I've moved out of that real quick, but it is open when if and when we get time, happy to debate it further. Now, of course, it's important to note that we have reciprocity reservation. This is more or less, we will only recognize and enforce arbitral awards from corresponding signatory states and citizens. So I think that's straightforward with respect to the applicability of the new convention in Kenya. And now I'll touch a bit on key or rather specific case law that touches on how courts have approached the enforcement and recognition of foreign arbitral awards in Kenya. And to begin with, just a few, a background, or rather one of the bones of contention, and not at the risk of not going back to the public policy discussion. So what happened recently, not so recently, but relatively given the amount or the length of time that the new convention has applied to Kenya, is that up until 2019, usually for domestic, and this particular, what's before you right now is addresses domestic arbitral awards, is when the High Court is the court of competent jurisdiction in Kenya that deals with any matters arising from enforcement and recognition, and of course, usually matters arising out of the subsistence of the arbitration, be it through any interlocutory reliefs, be it through setting aside, be it through enforcement and recognition. The High Court has jurisdiction, or rather the High Court is empowered by the Arbitration Act to handle matters arising that I've pointed out. Now, there has been a raising, or rather a debate that has been going on over recent years as to the appealability of a decision rendered by the High Court with respect to either setting aside or enforcement, or basically appeals arising out of an award that has been rendered by, or rather deliberations in the High Court that relate to an award that has been rendered by an arbitral tribunal. So recently, and that is in 2019, the Supreme Court of Kenya, through the case Mutu Agrovet Limited and Airtel Networks Limited, so the determination was that there is leeway to appeal. And the court was very, very specific. And you'll notice that it's, in as much as it said there's leeway, because there's a whole debate about finality of arbitral awards vis-a-vis administration of justice and meeting the ends of said justice. So the paragraph that I've italicized is more or less what the court really emphasized in terms of the door is limited in the sense that an arbitral award must have stepped outside the grounds of the said section. This is now with reference to setting aside an award, but I'll tell you how this is relevant shortly, and thereby made a decision so grave and manifestly wrong, which has closed the door of justice to either of the parties. Now, this is applicable to domestic arbitrations within the context of setting aside an arbitral award. However, this is also because the grounds for setting aside an arbitral award mirror the grounds for a court objecting to the recognition and recognition and enforcement of a foreign arbitral award, then in that respect, when it comes to the applicability, or rather, sorry, the appealability of a decision of an application for recognition and enforcement, then would that be subjected of an international arbitral award? Would that be subjected to this same standard that is applicable to domestic awards? And the answer to that is we do know. It is not concretized yet. We do not have a very clear position as to whether an international arbitral award that is before the High Court of Kenya, so to speak, for recognition and enforcement will be subjected to an appeal. However, it's important to know that this debate exists and it's still currently being deliberated, and the position with respect to domestic courts is clear. Then it's more or less at some point, maybe when apt jurisprudence comes our way in terms of a further case precedent, whether the same principle will apply to an international foreign award, or rather, yes, an international foreign award. Now, a few other cases just to touch on how the courts have approached, or what courts usually consider when deliberating on enforcement, recognition, and enforcement. And for starters, in the case of Glencore Grain Limited versus TSSS Grain Millers Limited 2012, the court, or rather this is the High Court, determined that an applicant seeking the recognition and enforcement of an international arbitral award in Kenya should not be turned away from the seat of justice on account of a lapse of limitation period, which is the award ought to have been recognized and enforced due to the court's delay. Now, I pointed out this case because in Kenya, in matters commercial in nature, we have a limitation period of 6 years. And because the New York Convention has been incorporated, so to speak, in our law, then it was by dint of said application that an international, or the recognition and enforcement of an international arbitral award would also be subjected to said limitation period of 6 years. Now, what this case does is it gives you a caveat. If the delay has been occasioned by the court in its deliberations, then it will not, or the parties will not be punished for said delay. However, the application of the Limitations of Actions Act, which is the applicable law when it comes to our limitation periods for various matters, then it will also apply here and it will be subjected to said law. So that was important for me to note and for me to present to you today. Hopefully, you will resonate with the same. Now, in Foxtrot Charlie Inc. versus Africa Aviation Handlers Limited and another, there's another 2012 matter. So this case had multiple heads in terms of what the court had came up with. And for starters, the court held that in breach of procedure and application on, or rather when it comes to procedural breaches, it won't preclude the consideration of an application on its merit. So that just goes to tell you that courts are not really hell bent on procedural technicalities if the merits are in order, so to speak, and will, if the case presents, will not pay much attention to it. Secondly, the court also held that when objector challenges the recognition of enforcement of an international arbitration award on the grounds of public policy, the court has jurisdiction to substantially interrogate the award in order to confirm it, and if it's consistent with Kenyan law, justice, and morality. So as pointed out by Emily, this is also more delves deeper into the applicability of Kenyan law and the tests that it has to satisfy the Kenyan law requirements, not just in statute, but also in precedent, so to speak, and also in terms of what Kenya would consider public policy with respect to justice and morality. Moving on, the court in this same case was also of the position that the recognition and enforcement of an international arbitration award in the case was disapproved for the reason that the arbitral tribunal imposed the arbitration agreement on the second respondent therein who was not a party to the same. So this goes to privity in the sense that if the court will also consider whether the enforcement will prejudice a party that was not privy to the initial arbitration, so to speak. So it has to be cognizant of said limitations when it comes to whether one party is going to be prejudiced, which is one of the grounds that I pointed out earlier under Section 37, in the sense that one party, in this case, who is affected by said arbitration award, has been impeded from being heard or being represented or being given access to speak their case, so to speak. Now, lastly, in this case, the arbitral tribunal disregarded issues of bribery, violation, rights, breach of fiduciary duty, and non-disclosure material facts on the part of the applicant. The court therefore held that the applicant cannot benefit from the legalities. So this is just an example of how the courts have interpreted the various provisions of Section 37 of the Arbitration Act 1995. And in this case, of course, with regard to bribery, which was a very clear provision under Section 37, and the fact that it considered that the arbitration tribunal, or rather the arbitral tribunal, did not consider this, and it was a clear-cut ground for not recognizing and enforcing said international arbitration award. I think this is the second last case. So basically, in this case, Tanzania National Roads Agency, the court declined to recognize and enforce an international arbitral award on the ground that the tribunal had, in contravention of the arbitral agreement, applied English law as the applicable governing law was Tanzania. So you can see the general gist that I'm trying to point out in these cases is the court will strictly interpret Section 37, and it will interrogate the award and the substance of the award in line with what Section 37 provides, and it will do it in a strict sense, so to speak, so that the courts in their interpretation do not veer from very clear provisions, except where I've pointed out for places that are not so clear, like public policy. Or rather, not that they're not so clear, it's just that they'll manifest in various ways. In the Royal Exchange PLC versus Patrick Nyaemba Tumbo 2019. So in this case, the court denied recognition enforcement of an international arbitral award on the ground that the respondent was not served with the requisite arbitration process notices and pleadings, and therefore was denied an opportunity to participate in arbitration. So this is also impeding justice. So as you can see, the reason I brought these cases up is because it's not anything that's beyond what has already been provided in the Arbitration Act of 1995 in terms of how the courts approach it. The courts are very literal in their interpretation. They're very strict, they're very by the book, and it's only, or rather there's only, it'll stick to what provisions, or rather the tests that have already been provided under law, and it'll also apply the various, or rather in terms of now public policy and what is considered applicable Kenyan law. So of course the award cannot contravene local law, and the award cannot contravene or go against what Kenya considers public policy, of which has been aptly demonstrated in the case that I've talked about, that is Christ of all nationals, and the one that Emily also pointed out. Now, in conclusion, it's this is my wording, by the way. I think, or rather, the progressive approach, so to speak, is how I've chosen to phrase it. And in my view, Kenya has taken a progressive approach in recognizing and enforcing international arbitration awards, in the sense that it hasn't really gone against the spirit of the New York Convention, in the sense that if an award is aptly before it, the merits are clear, and there are no grounds under Section 37, then there's very little reason to impede enforcement of said award. And as I pointed out at the beginning of my slides, the fact that we have a very robust legal and institutional framework, the same goes for the attitude of courts with regard to arbitration, and it's also enshrined in our constitution. I think that's Article 159(2) of our constitution, that's the Constitution of Kenya 2010, where ADR in general, which also incorporates arbitration, so to speak, has been recognized as an applicable dispute resolution method and mode of access to justice. So in terms of the general approach our country is taking in arbitration matters, including the enforcement and recognition, is a very positive one and a progressive one, as I pointed out here. And it is important to note, lastly, that Kenyan courts are they're fairly strict in terms of the scrutinized international arbitral awards against the provisions of Section 37, as I've pointed out, to ensure that the award is in consonance with the Kenyans, or rather with Kenya's minimum thresholds for justice. So I think I'll close it at that. I hope I've been quite crystal. If not, chat is available. I'm willing to respond to any issues or any questions that may arise. But that is all I have to say, and thank you very much for your time and space.
Thank you, James, for your very thorough presentation and very interesting review of the case law. I think that that first case that you mentioned as with respect to setting aside and whether or not that will be transposed to enforcement procedures is definitely something to watch. This has been great for me as well to listen. I've learned a lot, I've taken some notes. I'm very conscious of the time, and we have so many good questions in the chat and in the Q&A. So I will try to address one, and then I'll try to assign some of a question each at least before we wrap up. And Tabitha, you can let me know if we're running out of time. There's one question that I saw directed to me, I believe, that I saw twice, and this has to do with, I'll read it out loud. Can Article 5.1a of the Convention apply as the conflict of law rule in determining the law applicable to the arbitration agreement? So this question kind of pinpoints or kind of picks up on one of the most difficult ambiguities in the convention, in that Article 2, there's gaps in the convention in terms of what applicable law applies to where. Sometimes it's mentioned, sometimes it's not. And Article 2 doesn't mention the applicable law to assessing the validity of the arbitration agreement. So this question, but the other area in the convention where the invalidity of the arbitration agreement is raised is in fact Article 5.1a, and there the article says that validity is assessed, I guess, either by the law chosen by the parties or in the absence of such law under the law of the country where the award was made. And unfortunately, the answer to the question, to my knowledge, is not straightforward, but I do know that it can be used, or this kind of choice of law directive in Article 5.1 can be used by analogy to argue for the applicable law, or to determine the applicable law under Article 2. But I think for a definitive answer, it would be worth looking at case law, especially in the jurisdiction where one is looking to rely on an arbitration agreement. So unfortunately, that is the extent of my answer now from what I can think of right now, but I do know that it can be used by analogy, or it can be used as a directive to instruct courts on which law to designate to determine the validity of an arbitration agreement under Article 2. I hope that's okay for now. Much more research would be needed to kind of localize that answer to a specific jurisdiction, but for the moment, that's what I can offer. Thank you for the question. I see, Chris, you've gotten a lot of questions about Nigeria in the Q&A. I'll give you the floor if you'd like to answer one of them, but perhaps we can go in order of which one came in first. There is one from Efemena. Is the Nigerian court's decision to adopt a somewhat discretionary approach to the enforcement of arbitration agreements, rely on Section 5 of the Arbitration and Conciliation Act, due to Nigeria's transposition of the New York Convention under the limited scope of Section 54 of the Act, such that it appears that the New York Convention only applies to the recognition and enforcement of an award rather than to the enforcement of an arbitration agreement? Now, I think the Act applies to arbitration agreements. Do you want to address that one quickly, Chris?
Yeah, I mean, it's fun, the funny thing is, the person who asked the question, Ifemina, is actually my very good friend, and we're just chatting, discussing this question. So I don't think he actually asked two questions, and they are somewhat related. But in my opinion, I don't think I quite agree. I feel like, even if I understand this point, that it appears that the adoption of the New York Convention in Nigeria only quite limited to just enforce. But then if you look at it appears my network is terrible again. Can you hear me?
It's breaking up a little bit.
Okay, so I feel like even I don't think even if section 4 and 5, the provision of section 4 and 5 appears to give the courts the discretion to stay proceedings. Now we have to look at what the courts have actually done. They've not seen that provision as more of a discretion. They've seen it as more of an obligation. So that's even if what the data available shows that courts rarely, I mean, just 31% of the time that they stayed proceedings. The time when they did not stay proceedings, even in jurisdictions where they actually adopt the express provisions of the law saying it's mandatory, even in those jurisdictions, the reasons why the court do not enforce, those applications for stay here will still apply. So, and again, for some of the, we have to distinguish between the Arbitration and Conciliation Act, and also there are some state laws in Nigeria. They actually seem to create they directly say you must actually refer parties to arbitration. Like if you check the River State arbitration law and also the Lagos State, it's not more of a discretion. It's more of an obligation. And even at the federal level, still in 2017, the CJN, that's the Chief Justice of Nigeria, actually released a circular, a practice direction mandating all courts to always stay proceedings, to see it, to enforce arbitration agreement at every instance, to see it as an obligation rather than as a discretion. So yes, I understand that section 54 might want to, kind of pass across the message that perhaps Nigeria only, adopt the New York Convention to the extent that it applies to just enforcement proceedings. But no, I think even if it's not really expressed, if you look at the operation or the way we've treated arbitration agreement here, it still reflects the practice in the New York Convention. So that's my own point. But I know my very good friend will still disagree. Well, that's as much as I will answer the question. So this is my own subjective answer.
Understand. Thank you. Perhaps you can discuss one-on-one when you meet next and continue the conversation. But thanks.
Well, sorry, if I might also comment, there's another question on public procurement, and I don't think I'll just say a very little thing in less than 30 seconds. So the person asked if it's mandatory. I don't think the Public Procurement Act, mandates that all public procurement disputes must be referred to arbitration. But to the extent that parties during the procurement of a particular public enterprise, then there's a contract for arbitration. Nothing stops them from going to arbitration in Nigeria, to the best of my knowledge. So that's it. Thank you very much.
Thanks, Chris. Yeah, I think it was Atkilet who mentioned a little bit about whether a public entity could contract or submit to arbitration with private parties in Ethiopia, and that was a follow-up I had actually for both Kenya and Nigeria. So thank you for answering. Atkilet, given the recent ratification of the New York Convention in Ethiopia, for Ethiopian practitioners who are interested in kind of getting into this space, what would you recommend they do to kind of build their practice in light of probably, hopefully, more cases and more enforcement cases being brought under the convention now that it's in force? What tips would you give to practitioners in Ethiopia?
As you can see from Chris and Jem's presentation, they have a number of cases to refer to and to see how the courts were implementing the New York Convention. But in the case of Ethiopia, it follows a civil system, and we do not have a case law which are reported to the public except for the decision of the cassation bench, which are really few cases. So for anyone who wants to start its practice in arbitration, it would be good to first go and collect future cases which will be decided by the Federal High Court on the interpretation of the New York Convention. So the first starting point would be collecting cases. That's how you can build your practice in the arbitration field.
Yeah, definitely. Thank you. I think more is always needed on, career advice, and especially from I consider us all young practitioners, so it's helpful to exchange tips like this and to network. Yeah. Okay, we're 5 minutes over time. I just want to ask one question to James, and we have one here asking about how the ratification of the New York Convention helped Nigeria and Kenya. Do you find that it reputationally worldwide, Kenya, has it attracted investment? Has it, what has it done for Kenya's reputation in the international arbitration space?
Yes, I saw that question. Thank you so much for that, Emily. And thank you to the person who asked the question. So for starters, has it helped? In the long run, yes. One of the one of the consistently developing areas within the Kenyan jurisdiction is a constant increase in popularity and also content of international arbitrations. And of course, international arbitrations stem from international relations, and in particular, two limbs: international commercial arbitration and international investment arbitration. We have seen an influx of various international investment, so to speak, agreements, and of course, contracts entered into between, so to speak, more foreign entities and local entities. And it is to their benefit and relief. And not to say that Kenyan courts are not the apt place to go, but from an investor's perspective, they would want to at least have the option of having the route to arbitration. And when it comes to enforcement and applicability of foreign arbitral awards, an award may be rendered that may have a substantial effect, or rather that may have an interest within our jurisdiction by the person enforcing it. So of course, it's to the benefit of international commercial arbitration, international investment arbitration, that there is an avenue that the award will be recognized here, because they can either seek relief from the local jurisdiction if they have anything to seek from this place. And it, of course, works in the inverse. We can enforce our awards or awards rendered here in foreign jurisdictions. So it works both ways, of course, and it opens up twofold, in the sense that more people will want to, so to speak, bring, or rather render or engage commercially, and of course in terms of investment with Kenya. And at the same time, Kenyans would want to or would have confidence that the arbitral award, or they'd have more confidence in arbitration in the sense that their local award can be enforced in jurisdictions that have, of course, ceded to the New York Convention. So long and short, yes, it has greatly helped us in terms of our international approach. Mm-hmm. Thank you.
Mm-hmm. Yeah, and I'll just add to that having done these webinars now for a little bit over a year, the speakers that speak directly to judges on this topic also really stress the fact that taking a pro-enforcement or stance by national courts and getting it right in terms of interpretation and application of the New York Convention is also going to kind of give the jurisdiction a safe reputation for foreign investors and litigants coming and trying to enforce an award in that place. So lots of moving pieces and lots of different components, but all equally important, I think. Of course, unless there's a judge here online that I don't know about, I think that advice, I guess the takeaway for us is to kind of, as practitioners, plead and draft applications and in accordance with how the law, and in following precedent in other jurisdictions and in our local jurisdictions as well on the correct application of the convention. Okay, I know there are a lot of questions still to be answered. Perhaps I could take them down and try to maybe circulate and answer them by written form later. And if anyone else wants to help, that'd be great. But thank you so much for your interest, everyone. And I think I'll give the floor to Tabitha for the closing remarks before we sign off.
Yeah, Thank you so much, Emily. So allow me to thank our speakers and speaker/moderator, Emily. You guys have done a fantastic job. I thank you for the time you've taken to prepare and also deliver your comprehensive presentations. I believe that we are all coming out of this having learned something. I know I definitely have. Some interesting points that I'd like to note is this conditional enforcement of an award, which Chris was talking about. And I know he mentioned it to me earlier, and I found that to be quite interesting. And there's something that you said as well in your presentation, Emily, where based on ICCA's review of case law, there might be a potential for refusing to recognize awards with respect to grounds which could have been raised earlier in the arbitration proceedings. I think that's a good point to note, because some of the cases which were coming out from this related to procedural issues that could have been dealt with much earlier. For example, not having the full opportunity to participate in an arbitration proceeding. I think from Articulate, what I know is really interesting is that arbitration agreements are being amended so that they can benefit from the convention. So I think that there's a lot of developments and space to watch, and I'm really excited to see how in a couple of months, years' time, we can progress these conversations. I would now like to thank our speakers. I'd like to thank ICCA and Young ICCA for leading us in this presentation. I would like to thank the LCA-YAN as well. I'd like to thank Chartered Institute of Arbitrators Kenya branch, YMG, and I'd also like to thank Africa In The Moot, who's also one of our partners. This has been an ICC YAF Africa event, and I'd like to encourage you guys who were not part of the network to please join the network. I've put a link to the website there. And I'll just say that this is a global network, and if you're part of the mailing list, you'll always get interesting emails about webinars, trainings, and opportunities for students and practitioners happening within your area. I'd also like to thank the ALN and Anjawala and Kana for supporting this webinar. And finally, thank you to all of you for staying with us until the end. We will share the link to the video. You all registered by email, so we have your email addresses, to the video on ICC Kenya's YouTube page. You can check the YouTube page tomorrow. The video will be up by then. Separately, there were some really interesting resources which ICCA has produced. And I think, Emily, if we can talk after this, providing the link for that as well in the email. And I think maybe any questions or any engagements which any of the speakers want to answer, we can also put that in the email as well. And lastly, you guys, you can connect with us on social media, LinkedIn platforms, to take up these conversations further. Chris, I know that you and your colleague are still in a bit of a debate, tug of war. So good luck, good luck with that. But yes, allow us to wind up. Thank you so much to the ICC YAF Africa team, Diamana and Sarah, for assisting us with today. So without further ado, goodbye, everyone.
Thank you. Goodbye, everyone.